extensive framework of rules, principles and practices. In that spirit, the Commission remains to be convinced about the opportunity of a specific legislation providing for a horizontal framework of an EU administrative law at this stage. Thank you.
Děkuji. Thank you much indeed. Now, time for our rapporteur, Madame Laura Ferrara.
Thank you, President. I'd like to thank the Commission and I'd like to thank all the colleagues who've spoken for their support, and I'd also like to thank the shadows once again. Transparency is the ultimate goal that we have to reach, but it's also a tool, it's an instrument to try to breach the gap between European citizens and the institutions in order to ensure that citizens are more involved based on the principle of participative democracy, and also to increase the trust which seems to be lacking towards the European Union today. I was disappointed to hear, including in some discussions with colleagues, that citizens aren't interested in certain policies or instruments, or they don't understand them. Some information isn't clearly understood or isn't accepted. Often things aren't understood because of the technical wording that's used or because of how technical some of it is. So the challenge that the European Parliament is facing, as well as the Commission and the Council, is to try to involve citizens more and to ensure that information is easier for citizens to access, to ensure that information is available and to allow citizens to decide what they're interested in and what isn't so interesting to them. So we have to make information easier to understand and easily accessible. It's difficult to find your way around the different websites of the different three institutions, so once again we want to have a one-stop shop for access to make it easier for citizens to use their right to information. In international negotiations such as TTIP, we have to involve citizens who aren't happy about the confidentiality of these agreements. We have to look at the influence of lobbyists and discussions between the three institutions in trilogues, for instance. And I hope that following this European Parliament opinion, as well as those from previous years, will help us move towards greater transparency. Thank you.
Grazie tante. Dziękuję bardzo.
Thank you. And now I would like to close the debate on this particular report, and I would like to remind you that the vote on the report will happen tomorrow. We move on to the next step, which is oral question to the Council and the Commission, transborder protection of children in Europe. We will have the first speaker on the list, the rapporteur, the author of the question, Mr. Swoboda. 2.5 minutes. The floor is yours.
Dear Chair, Commissioner and Minister, the Brussels IIa regulation has undoubtedly been a successful Union instrument that has benefited EU citizens through the creation of a wide-ranging scheme of jurisdictional recognition and enforcement rules in matrimonial and parental responsibility cases. That being said, we are all aware of its shortcomings when it comes to child abduction cases. In this respect, it appears that the regulation has been overtaken by events. That is to say, the growing number of transnational family dissolution proceedings, which has been aggravated by the increasing divergences between the legal rules applicable to family dissolutions. On top of this, family law, which is a competence of the member states, has been fragmented into different types of family models: marriage, registered partnership, simple cohabitation. As a result, it appears that society has moved on and that the regulation has been left behind. Members of the European Parliament are confronted with the shortcomings of Brussels IIa on a regular basis, not only in the Petitions Committee, but also in correspondence and contacts with citizens who are at the end of their tether. We are all aware that the law is a blunt instrument when it comes to family questions, that judges and lawyers are not necessarily the persons best equipped to deal with such questions, and that the courts not necessarily are the best or most cost-effective forum. We need to reflect on this and try to identify ways to help our citizens in these painful moments of their lives, while safeguarding and promoting the best interests of the child. The continuing success of the regulation will depend on its successful and targeted revision. Now that the main areas of complexity and malfunction have been identified, it is high time that appropriate action is taken to tackle the last remaining insufficiencies. Thank you for your attention.
Thank you very much indeed. And also author, Madam Cecilia Wikström, 2.5 minutes. Take the floor, please.
I thank you very much, Mr. Chairman, and I would like to thank the colleagues both in my committee, the Petitions Committee, and in the Legal Affairs Committee for their cooperation on this issue. It is our aim in my committee to improve our cooperation with the legislative committees to ensure that the citizens' concerns and experiences are taken better into consideration in the legislative process. In addition to the testimonies of the direct experiences and problems related to EU law, the petitions that we received also have an important role in helping to identify problems with the national implementation of EU law in the Member States. This is important when we discuss how we best can protect the best interest of the child across borders in Europe. In connection with the upcoming review of the Brussels IIa regulation, and also in the light of the increasing numbers of petitions addressed to Parliament, I am happy that this debate takes place here tonight. It's an issue of great importance. Because our committee has received a large number of petitions related to children welfare issues and their treatment by either judicial or the administrative bodies in the Member States. This is definitely a testimony for more cooperation in family matters with transborder aspects, and there is not only an urgent need to review the legal instruments, but also to try to find a way to avoid the harmful situations described in the petitions that we have received. We have ensured freedom of movement, but it is also our duty to take into deep consideration the consequences that citizens from different nationalities meet, decide to build a family, but as we know, couples can face problems and finally separate. That's why we must make all the possible efforts to put instruments in place to handle the situation in the best way possible, and above all with the best interest of the child as the paramount objective in all decisions. These two oral questions tonight have been raised in order to draw attention to the concrete problems that citizens are facing. Finally, on a more personal note, I am happy to see that my dear colleague Janine Hennis-Plasschaert is here representing Council tonight. I am sure that you will provide us with, as always, clear and fruitful answers to the question raised. And the same goes, of course, also for Commissioner Vera Jourova. Thank you very much for your deep consideration on these important matters. Thank you very much.
Thank you. On behalf of Council, Madam Minister Janine Hennis-Plasschaert.
Mr. Chair, thank you very much, Madam Commissioner, honourable members, and many thanks to Cecilia Wikström for the very kind words. I would like to recall the importance the Presidency attaches to the work on civil law, in particular on family matters and e-justice solutions. And I take this opportunity to thank the chairs of the Legal Affairs and Petitions Committees, Pavel Svoboda and, of course, my previous colleague, Cecilia Wikström. I thank them for coming with these questions and ideas to complement the EU measures already in place to protect the best interests of the child in cross-border situations. Now, on adoption. As you know, the issue of adoption of children is a matter which is not regulated at EU level, but by national laws and by some international conventions, particularly the Hague Convention of 1993, to which all EU member states are parties. This convention aims at protecting adopted children in their countries, if possible, by offering them a home in those countries. It provides for cooperation between the authorities of the different states. Now, the Council may adopt measures concerning family law with cross-border implications, following Article 81.3 of the Treaty, including in the field of adoption, but only on the basis of a proposal from the Commission. Now, on welfare and child poverty, concerning the issue of the welfare of children, I would like to say a few words on the fight against poverty, which is a complex reality affecting many children, unfortunately. The fight against poverty is one of the objectives of the Europe 2020 strategy, and it's also one of the Presidency's priorities. Now, working closely with the Social Protection Committee, the Presidency has therefore tabled Council conclusions on an integrated approach for combating poverty and social inclusion. In this document, which is to be adopted in June, the Council encouraged Member States to address child poverty and promote children's well-being through integrated strategies in accordance with the Commission recommendation Investing in Children. And the Council will also invite Member States to intensify the exchange of knowledge, experiences and best practices in this field. And let me mention in particular the Roma children, because yes, we must also continue to address other long-standing challenges as the situation faced by Roma children. And I do thank the European Parliament for keeping this issue on the EU agenda, including on International Roma Day earlier this month, April 8 to be precise. Now, as regards mediation, the EU has put in place the 2008 Mediation Directive, which aims at facilitating access to alternative dispute resolution. It promotes the amicable settlement of disputes by encouraging the use of mediation and by ensuring a balanced relationship between mediation and judicial proceedings. Moreover, the Brussels IIa regulation foresees mediation as one of the functions of cooperation between central authorities in matters of parental responsibility. Now, there is common understanding in Council that the revision of Brussels IIa is a topic of great importance, and to be honest, it is about time. On e-justice. On improving access to information in the justice field, you know that the e-justice portal was launched in 2010 in collaboration with the Commission and the Member States. The Council's second action plan on e-justice stresses that information related to minors should be included in the e-justice portal. A specific expert group is now examining the ways to expand the information on minors already available on the portal. And your specific question relating to adoption procedures could indeed be considered in this context. Now, in closing, Mr. Chair, I wish to say that the Council awaits with great interest the Commission proposal amending the Brussels IIa regulation, as this is the cornerstone of EU judicial cooperation in matrimonial matters and matters of parental responsibility. I thank you.
Thank you, Valis. Thank you. Madam Minister, now time for our next guest, Commissioner Vera Jourova. Take the floor, please.
Thank you for proper pronunciation of my name. Mr. President, honorable members, I would like to thank the Juri and Peti committees for organizing this debate, which I very much welcome. As has been said several times here already, the Brussels IIa regulation is an extremely important piece of legislation for many families in Europe. It has been applied for 10 years and proved to be very useful, but time has come to review it. The Commission intends to come forward with a proposal late June this year. Our assessment is that the Brussels IIa regulation works overall well with regard to matrimonial matters. We do not envisage at this stage the need to revise it in this respect. On the other hand, there is clear evidence for the urgent need to revise the regulation as regards parental responsibility aspects. You, better than anyone, are aware of numerous cross-border cases in which the judicial cooperation based on this regulation isn't fast enough, to say the least. The children end up being hostage of lengthy legal disputes. The mechanisms put in place by the Brussels IIa regulation have helped in determining parental responsibility or settling child abduction cases, but we have to take additional steps. I intend to further clarify the rules on parental responsibility, to improve the enforcement of judicial decisions, to speed up the procedures and make sure that the best interests of the child are of primary consideration and effectively protected. More concretely, we are considering measures on the following aspects. Firstly, to speed up the return procedure. There are still far too many child abduction cases in which parents with an enforceable return order are stuck in lengthy proceedings. Abducted children must be returned swiftly, as passing of time can have irreversible consequences for the relationship with their parents. Evidence shows that in those member states with specialized courts, the return procedure can be much smoother and quicker. Secondly, to see whether the existing exequatur procedure is still needed and to define the grounds for refusal for the enforcement of judgments. It is unacceptable that currently a parent can be left without any possibility to see his or her child for years due to delays in the enforcement of judgments. Thirdly, to increase judicial cooperation and mutual trust between member states, for example, when it comes to the specificity of family proceedings. Fourthly, to smoothen the differences in national rules governing the hearing of the child. Too often these rules are invoked to refuse a judgment from another member state, and I am convinced that while acknowledging different legal traditions, we can and must do better to respect the child's right to be heard. Finally, to improve the cooperation between national authorities with responsibility for child protection or parental responsibility matters. We need a strong network of these authorities to help parents in enforcing their parental rights abroad. Besides these key changes to the Brussels IIa regulation, we will also continue our awareness-raising activities, targeting also child welfare and consular authorities. This is duly reflected in our funding, priorities and calls for proposals. To conclude, let me refer to the aspects related to adoptions. The Brussels IIa regulation does not cover these aspects. The functioning of child protection and welfare services is governed by national law. The Commission has thoroughly examined the numerous petitions concerning adoptions without parental consent that you have recently received. None of them falls into the remit of EU law. However, the Commission is contributing to the elaboration of a common understanding of how the rights of the child can best be protected and promoted. For instance, let me point to the 10 principles of integrated child protection systems, which were debated in the last European Forum of the Rights of the Child and which are also mentioned in your draft resolution. We will continue to support Member States in implementing a child right-based approach. And I know that also you, through dialogue and awareness raising, can have a real impact on improving the situation on this very important matter. I am looking forward to our close cooperation on these files in the best interest of children and for the benefit of families in Europe. Thank you.
Děkuji. Thank you much indeed, Madam Commissioner. Now it's time for representatives of political groups. On behalf of EPP, Madam Roberta Metsola.
Thank you. We are currently living in an age where multinational families are on the increase. In the European Union, there are hundreds of thousands of these families, and they should be offered support even when the relationship disintegrates. These families look to the Petitions Committee to give them a voice. Therefore, I would like to support Cecilia to emphasize the significant role that the Petty Committee can carry out with regard to children's rights. As the Commissioner and the Minister said, we must never raise false hopes by implying that we can solve every problem that is put before us. We must not forget that this is mainly a Member State competence and not an EU one. However, there are several cross-border cases where, yes, we can certainly step in and do more to ensure that children's rights are protected and strengthened. This should be our highest political priority. Therefore, on my own personal initiative as well as that of other colleagues, we wanted to open this up to as many Member States as possible. We have come together to question the Council and Commission on the work being done in this area. Therefore, as the Petty Committee, we have come together to present a resolution from all the groups on a number of issues regarding child protection in Europe. This is another way of lending a voice to those who submitted petitions to the European Parliament. I appeal and I conclude by saying that all the members of this House should put aside their political label and address the reality facing us. When children are involved, there are no compromises that can be accepted, and we have to protest their best interest ultimately. Thank you.
Thank you. On behalf of SND Group, Deputy Josef Weidenholzer, 1.5 minutes. Take a floor, please.
Thank you very much, President. It's important that the Brussels II regulation from 2003 be revised, above all because it refers to relations between different states, and often that's insufficient. Cross-border cases can't be restricted to just 2 states. Often it is a question of several states, and so there's several legal conundrums that crop up. There's a Belgian and French people who are involved in a struggle before the courts, but none of them live in Belgium anymore. And there are many cases where several states are implicated, and I think the revision of the Brussels IIa regulation has to take that into consideration. The lack of legal clarity and the question of unclear deadlines means that children suffer as a result. We see that again and again it's not in the best interest of the child the way these things are done. So the rights of the child have to be strengthened in the Brussels IIa regulation, and we have to try and make sure that the proceedings are kept as short as possible. There has to be very clear laws applicable, and there has to be a clear understanding of what the future holds for a child, and that is decisive, of course, for the future of their lives.
Thank you very much indeed. On behalf of ECR Group, Deputy Ulrike Carlsson, 1 minute, take a floor, please.
Tak til præsidenten. Mennesker mødes i
Thank you. People meet each other in Europe, they fall in love, they have children, and everything goes very nicely. But in many cases, this love is not eternal. Couples split up, and children have to be shared out amongst the couple. And sometimes in this process, it's not so easy. They may come from different countries, and it makes the situation even more difficult to solve. In the Petitions Committee, we often see cases where member states and their courts can't agree on their evaluations of these types of cases. In many cases, member state courts will defend the interests of their own citizens, and the child becomes hostage to these types of problems between the interests of different member states. This proposal isn't trying to force member states into doing anything. This is a proposal to ensure that we have good agreements which will ensure that children of parents of different nationalities are treated fairly. That's in the interest of everyone, particularly in the interest of the child.
Thank you. On behalf of ALDE Group, Deputy Antonio Marinho Pinto. 1.5 minutes, take the floor, please.
This debate clearly points to the specific problems faced by European citizens in terms of children's rights, where there are different jurisdictions involved, 2 or more. Increased mobility within the European Union inevitably means an increase in cross-border court cases involving children, so it's a pressing matter, an urgent matter to boost the judicial cooperation between member states, this in terms of training and exchange of good practices between social services and the courts that deal with such cases, that is to say adoptions or abduction of children, but generally speaking all jurisdictions covering family issues. There is a degree of social alarm generated in some of these cases, so the EU's authorities should encourage the member states to create specialist courts with exclusive competence on such cases. Here we can't hesitate, we can't talk too much or talk it around the houses. What must take primacy is the interest of the child. Now, we're not seeking to impose a single vision or single approach to these issues, but rather we want to turn the European Union into an area of free circulation of people, not just of goods, services and capitals. Thank you.
Obrigado. Thank you. On behalf of GUE NGL Group, Madam Kostadinka Kuneva, 1 minute, take the floor, please.
Thank you, Chair. There is something rotten in the state of Denmark concerning child protection. We have petitions in the Petitions Committee concerning the care and the welfare of children in the UK, in Denmark or Germany, and their number is like an avalanche. They are either about child services or adoptions or children taken into care or visitation rights, or even the rights of parents that have been accused of sexual abuse, and those things are shocking. So we have a lot of petitions that mean that there is a crisis of the institution of family in the north, and at the same time we cannot answer to the question what happened to the 10,000 unaccompanied minors, refugees that entered the EU and according to Europol are still missing. So I would like to ask you to commit to full support of the rights of children with decision, with concrete decisions. And we should also face the other humanitarian crisis we're facing in the south, the refugee crisis, and this is an ethical obligation. Thank you.
Evharisto, Благодаря. Thank you very much indeed. And now, on behalf of Greens, FA, Madam Tatiana Zdanoka. 1 minute, take the floor, please.
Thank you, Honourable Minister Denis Blachard, former colleague, and Commissioner Jourova. Thank you for your statements, and I hope that Council and Commission will take on board our resolution, which is prepared just on studying the desperate calls for help addressed to our Committee on Petitions. It is evident that following the significant level of movement of workers between member states and the increasing number of mixed couples, the number of cross-border child protection issues involving custody removal is growing as well. I will give only one number showing how this problem is actual for my country, Latvia. During the only two first months of this year, 11 children were withdrawn from the families of Latvian citizens working in Britain and placed in British care families. The cross-border mechanisms are to be put in place when it involves determining over the custody of children. We need to input the receiving state the duty to inform the consular authorities of the state where a child is a national of, and a clear, gently detailed and developed definition of the term habitual residence of the child in the revised Brussels IIa regulation is needed.
Thank you, Madam. Do you accept a blue card from Mr. Tomasz Zdechowski? Yes? Mr. Zdechowski, take the floor, please.
Vážená paní poslankyně.
Thank you. Colleague, you have mentioned a case when children were taken from your nationals in the United Kingdom. However, even more children were taken from Latvian families in a non-EU member state in Norway. Do you think that the European Union has been protecting sufficiently the rights of children and families in other than EU member states? Thank you.
Time for answer, Madam.
Although Norway is not an EU member state, we, as a Committee of Petitions, when hearing these cases in Nordic councils just last week, we put a lot of attention to also, alongside with Swedish and Finnish and Danish cases, also Norwegian situation. But United Kingdom is only one state where adoption without consent is working, and that's the biggest problem now for EU member states.
Paldies, thank you much indeed. And now on behalf of EFDD Group, Honorable Leonora Evi. 1 minute, take a floor, please.
Thank you, President. It's vital to improve legal cooperation between member states in cross-border cases that involve minors. We have to guarantee that sentences are recognized between different member states and that they are respected, and in order to ensure that parental visiting rights are respected, or perhaps minimal standards for hearings for minors in courts, and also ensuring social protection for their rights. We can't forget cases of abuse. For instance, in Germany, a very recent case has been one of a father that was separated from her 2 children by their German father. This is clearly unacceptable. The notion of a child is still vague and is applied very superficially in cases. The European Union can apply rules to protect competition and banks and financial instruments, but it can't protect the rights of people and of children.
Yes. Thank you very much. Mr. Le Breton. Thank you, Mr. President. The questions raised by the European Parliament face 2 difficulties. First of all, I am hostile to the idea of automatically acknowledging or recognizing adoptions in the member states. It would lead to same-sex adoptions or adoptions from in vitro produced children, and I accept neither of these 2 possibilities. Also, I mistrust notions such as the interest of the child, which is being instrumentalized to do away with the traditional family living together does this kind of thing, and basically what this ultimately does, what this thinking does, is take away the child away from the family. I think the real interest of a child is to grow up in a family made up of a mother and a father.
Señora.
Thank you very much, Ms. Pitera.
Dziękuję, panie przewodniczący.
Thank you, President. Every year, the European Petitions Committee receives many petitions on children. The scale of the problem shows that we need urgently new instruments for cross-border cases. The problems that we have identified refer to many areas. One of these areas is insufficient implementation of Brussels II regulation. Other problem is the lack of transfer of information when it comes to protection of children, especially when we have trans-border cases. We also have complaints that refer to failure to implement a given court decision. The system that we are going to build has to be multidimensional, has to use many instruments. The Polish experience shows that many problems relate from poor access to information and legal aid. That's why it's very important to have a relevant financing system in place, especially for those bodies that provide information and provide assistance. It would be best if we had one pan-European hotline. We also should publish guidelines that would allow citizens to become more fluent when it comes to the usage of such laws in various member states, because sometimes it's the issue of not knowing what laws are in place. Such actions should be urgently taken. If our words as politicians saying that the interest of child is the most important thing should not stay on paper.
Thank you very much, Mr. Martin now.
Madame la Ministre, Madame le...
Minister, Commissioner, I'm sure that you are convinced that Europe is built on sound foundations, free movement of people, free movement of goods, and free movement of love. Yes, why not? Free movement of love. Erasmus is about love as well. It's allowed more than 2 million students to discover a new country. And if I understand the study right, the Commission's produced about 1 million Erasmus babies that have been produced. For that reason alone, long live Europe, long live love. And sometimes love fails and crumbles, and even when children are there. But Europe is not just love, unfortunately. There are social problems, there are accidents of life that strike families and sometimes those most vulnerable. And we see that national laws are not always able to deal with third countries when we're talking about family members coming from other countries. Then you have families who suffer, and above all the children suffer. Of course, nobody's claiming that the various decisions taken here or there will go against the interests of the child, but sometimes you can have good faith and make the wrong decisions anyway, because you have to think about several people at the same time. We have to do everything to make sure that the member states collaborate and cooperate by understanding the best possibilities available and not accept any taboos to achieve that. So, of course, this will not be a panacea of all the problems in Europe, but I think we wanted to send a clear message to the Council, to the Commission and to the Member States: no borders for rights of the child.
Thank you, Ms. Zitnanska.
Thank you very much. Even though generally it's best for the child to grow up in its biological family, it's not always possible. Children face violence, abused, are neglected, and then it's important for the social services to intervene. In the EU member states, there are often cases where children are forcefully withdrawn from their parents, even though there hasn't been a case for abuse, and with a bit of help these families could have been functional. Instead of giving the closest relatives the opportunity to care for the children, these children are put up for adoption. They are given to complete strangers, and it's impossible for them to keep in touch with their parents, with their siblings. Not every single foster carer is aimed at the happiness of the child. Some of them are more interested in financial benefits, and therefore we can't really speak of a solution with the best benefit for the child. I welcome this resolution, which aim is to improve the rules in the EU, also to improve the rules for case of difficult divorces, also to offer interpretation services, legal aid, improve cooperation between the member states. This everything could bring what we aim in this resolution, that is the best benefit of.
Thank you very much, Mr. Ornano. Thank you, Mr. President. Today's an example of the kind of pernicious manipulation of the law or rights, the rights of a child in this case. Now, apparently there are situations which I acknowledge are complex in terms of mutual recognition for children, but the European Union has decided to step in for member states and decide, and I say thrice no to this. The EU shouldn't tinker with issues pertaining to the rights of the family. Europe is not the sole guardian of rights. You have no right to judge on national law in the name of the Charter of Fundamental Rights when there are clearly no breaches of this Charter, just some conflicts of law. It's not in the interest of a child to open the door wide open to European recommendations in favour of recognition or allowing medical procreation of doubtful nature and the destruction of our natural model of the family. We will not give up on this. Thank you very much. Ms. McGuinness.
Thank you, Chair. After that last intervention, let me just bring the debate back to its core this evening, which is about children in cross-border situations. I have to say, even though it's rather late in the evening, I've been very impressed by the contributions from Council and Commission. Very often you get criticised, but I thought you were very honest and open on this very sensitive issue. In my role as children's rights mediator on this issue in the Parliament and in the Petitions Committee, we come across the saddest of cases. And we try in my office to bring about mediations. We do it very rarely because usually people come to us at the very end stage. And I would appeal to the Commission, and you've mentioned mediation, to do as many member states are trying to do, bring mediation in early so that it can fix problems without that tension and adversarial system that is the courts. And I think if member states do that and we look at it at a European level, it can be very, very helpful. Clearly in the Brussels II review you've mentioned some important points that have got to be looked at. It's about timeliness. A child removed by one parent from the other needs to be returned to its home in a timely manner, and we have several examples of member states who are not doing that. Lastly, as time is short, we need judicial cooperation to be enhanced. We need to have informal networks for this to work properly. It is a problem that will not go away, and it needs our eyes watching very carefully, but I've been pleased that this evening there is some at least talk of progress. Thank you.
Gracias, señor Cofferati.
Thank you very much. Mr. Cofferati now, please.
Thank you, President. Commissioner, I've heard how the questions that we're discussing have been in a lot of the petitions that have arrived at the Parliament in recent years. As we've heard several times, there are certain types of problems. One is the negative effects of matrimonial law, and this is being increased because of the increasing case of travelling, of marriages cross-border, and often the child at the end of this becomes the subject of competition or quarrels, which is very damaging to the child. Then, of course, we need to talk about social protection. We can't just give the child to custody of one of the parents. We have to ensure that these people have sufficient protection to live in a dignified way. Also, poverty is a question here. Poverty has increased in all European countries, including in the richest, because there is a gap between the more stable parts of society with the higher incomes and those which are more fragile. And the children, of course, are at the front line of this. Any type of policy to protect these and to try to fight poverty has to take account of children. They have to be the absolute priority. That has to be our starting point.
Señora Sojdrova.
Thank you very much, Ms. Šojdrová.
Madam Commissioner, colleagues, I am happy that we are unified in what the best interest of child is. This is living with the parents, and if not possible, then the child should go to the closest possible relatives, and only on the third place to institutions. The European Union promotes mobility of individuals and families, and it is necessary to put on the European level the decision making, or maybe to have some minimum standards in all countries. I think that what Madam Wikström proposes is very positive. We think that we need a cooperation between the member states. We need to create a platform which will help citizens in these situations. Prevention is crucial, and that's why we want a better social and legal protection and social services. Member states play a crucial role, and that's why we want them to have some measures like specialized courts. Of course, if children should be put in custody, then also brothers and sisters should be put together in that custody. Also, the problem is when parents lose their rights for having their children with them in third countries. Thank you.
Thank you very much. Ms. Curtin-Darling now, please.
Thank you very much, Chair, Commissioner, Minister. As a member of the Petitions Committee, we received hundreds of petitions, mostly from parents, about child welfare questions. We've heard first-hand of the problems faced in securing the best interests of the child in cross-border cases from some very desperate parents. There are estimated to be up to 2 million British people living around the rest of the EU, and an equal number of EU nationals living in the UK. Freedom of movement has brought our citizens unprecedented opportunities, but now we must ensure that our legal systems and judicial cooperation develop at a similar pace, especially when families find themselves in a difficult situation. The concerns raised by citizens demonstrate the clear need to enhance and develop cooperation and information exchange across borders. We've heard calls for a more common understanding on the best interests of the child in line with the UN Convention on the Rights of the Child, which must always be paramount. And I'd like to hear from the Commission what's intended in this respect. Family law is a national competence, and Member States therefore have a strong responsibility to ensure that they address the increasing pressure on social workers and social services by ensuring that family courts and social services are fully supported and well resourced, and that parents and children receive the support needed to understand the legal proceedings they're engaged in and their rights. Finally, we need to stay at the table to negotiate, to ensure the rights of British children and other children in Britain, and that means we need to remain inside the EU. Thank you.
Gracias. Señor.
Thank you, Madam. Mr. Buda.
Thank you very much, President. An investment in children, of course, is an investment in the future of our society, and their education and upbringing in appropriate and dignified conditions should enjoy the highest priority everywhere. The Commission and the Council should make sure they adopt appropriate measures to guarantee that the best interest of the child in the case of a cross-border adoption is guaranteed. It's very important in these sort of situations that children have a possibility to remain in contact with their own culture and to learn and speak their mother tongue. And the parents involved in these issues should make sure that the siblings are not split up. We have to make sure that the best interest of the child is identified and protected by the prosecuting authorities. We have to understand that they can enjoy EU citizenship even if they're outside the EU. We have various trade agreements with the EU, such as Norway, but they are trampling on the social rights of Europe by abusing this particular situation. A 3-month-old baby still being breastfed was taken into a foster family without any legal decision on the basis of an administrative decision for unsubstantiated reasons, and that's unacceptable.
Thank you, Mr. Radev now.
Благодаря, господин председател. Уважаеми колеги, има много проблеми.
President, colleagues, the application of Brussels 2A is causing problems for many families and the interests of their children. And I'll go through some of these problems. First of all, the adoption practices in the European Union without the consent of their biological parents. There have been many cases in the United Kingdom where this practice has become a business. I would call upon the Commission to take the measures necessary to put an end to these practices. Secondly, we have to promote cooperation and exchange of information between courts, as well as between social services and national administrations in Member States. Finally, I would like to emphasize the need to respect the different social and cultural traditions in Member States. It's in the child's interest to stay in their family, even if they don't have the same place of residence as the children. This is particularly true of young children for who the concept of habitual residence is a bit vague.
Ms. Esteras. Thank you, President. Indeed, in the Petitions Committee, we've looked at a number of petitions relating to problems that arise when families that are international break down. Now, this kind of thing happens because now there's more mobility and there's more multinational families. Now, it's the minors' interests that must prevail. There's the 2003 regulation, and over time we've seen the gaps, the shortcomings. So that's why it's good that we're having this debate, because we do need a revision of this regulation. First of all, we need to have guarantees about the rules and authorities that are applicable so that we have legal security. Secondly, free circulation of court rulings, because sometimes a court ruling in some country is not implemented as quickly as it should be in a third country. Thirdly, rulings have to be genuinely implemented in time. And there can be appeals in some cases, and that of course leads to delays. Fourthly, in cases of abduction, the authorities have to act quickly. 6 weeks is the time frame, but that's got to be respected. Fifthly, returns should be quick and efficient. As Ms. McGuinness pointed out, I have full confidence in the Commission. I think you've really homed in on what really has to be done, and done quickly, because it's very important for the future. One comment: some colleagues have used this debate to attack same-sex couples, and we don't. I can't accept any form of discrimination. Thank you, says the President. Ms. Comodini.
Grazie, Sir President.
Thank you, Chair. For many families where there are disputes, the best interests of the children looks like a fairy tale, but there is protection, but nobody exactly knows what that is. Some of this comes from the fact that that each child has its own particular interest. As a member of the Legal Affairs Committee, I am very concerned about the fact that the EU has failed to implement clear procedures to determine the best interests of the child. However, many difficulties arise from the lack of authorities that are directly involved in cases such as those that adopt common knowledge based on common standards. There's an aspect which should be a priority, and that is that in each process we should integrate measures that protect children from damage that can arise from the situation of the family, and the fact that they are separated from their parents, and the fact that they don't have the opportunity to develop a relationship with their own family. Thank you.
Gracias.
Thank you, Madam. Now we move on to Catch the Eye. Mr. Zhtekovsky first. 1 minute.
President, Commissioner, Minister. When I studied in Rome, I received a card from a bishop reading, "Each child which is born is good news from the God." And I believe that this is very true. Many cases have been mentioned. I'm going to mention one more case of Eva Michalakova, a Norwegian case. 5 years ago, a child was taken away from the Czech mother and father based on sexual abuse allegations. The allegation was never proved true. Never ever, and still the child was not received by the biological family. Eva Michalakova is a European citizen, and what has the EU done for Mrs. Michalakova to help her get her children back? This is a crime, and our children will never forget about them, and we need to address them. Thank you.
Caputo. Thank you, Mr. Caputo. Now, please.
Grazie, Presidente.
Thank you, President. Protection for minors is one of the biggest challenges that contemporary society faces. In recent decades, there have been international agreements that have recognized that minors have particular interests, particularly when it comes to access to information. It's necessary to increase cross-border cooperation on minors and to promote mediation and conciliation, particularly taking account of all of children's interests. We need to have policies that will support families to reduce the use of these social support systems. It's fundamental that Europe has to be able to guarantee protection for the rights of everyone, and now more than ever this has to be an absolute priority, and nobody should feel that they are exempt from that.
Thank you, Ms. Ward.
Thank you very much, President. I would like to ask the Commissioner and the relevant authorities to make particular efforts to involve children and young people more fully in decisions affecting them. Participation is also a children's right, but it is frequently infringed and poorly promoted. Working with organisations experienced in child participation is, in my view, a good way to develop institutional practice that would better protect the best interests of the child.
Gracias. Señor Marías.
Thank you very much, Mr. Marias.
Thank you, Chair. As a member of the Petitions Committee, I have seen hundreds of petitions concerning the best interests of children. First of all, in cross-border adoptions, we need to have security of law so that we will have the best interests of children in mind, as well as keeping in mind the rules of citizenship of the Union. A lot of parents have worries concerning the practices of adoption of certain member states that are really problematic when the parents or the families move from one country to another. At the same time, we should drive down bureaucracy concerning the procedures of parental responsibility so that the Hague Convention of 1993 will be applied correctly. At the same time, we should exchange best practices between member states, as well as set up specialized courts that will deal with cross-border child abductions. Thank you very much.
Señor Jakovic.
Mr. Jakovic.
Gracias, Presidente.
In conflict situations, when there are problems between matrimonial couples and parents, as a rule, children are the ones who get hurt. As a rule, the parents are selfish, and very often they're simply trying to protect their own personal interests, or even their love towards the child, which is perhaps not directed towards it. What we should do is that, since we have mobility and people living together from different countries, and with all of this present, we need to do whatever we can to have proper European level of legislation. And another detail is important here. There are numerous situations in the Balkans, where I come from, and people living in these countries, in candidate countries, are also connected in many ways with the member countries. And please be so kind and keep in mind this in future talks with these countries. Thank you.
Commissioner Jourova, you have the floor.
Yeah, thank you very much, Mr. President. Thank you very much for this debate, which, as I expected, brought here many very sad and serious true stories which we see in Europe, and where, as has been said, the children suffer, and it's our duty to address the situation with the proper legislative act. Several of you mentioned adoptions without parental consent, so let me repeat that the adoptions are regulated at national, not at EU level. Adoptions are therefore not also in the scope of the Brussels IIa regulation, but it can be generally noted that Article 21 of the United Nations Convention on the Rights of the Child imposes on participating countries to ensure that the best interests of the child is the paramount consideration with regard to adoption. But the Convention does not preclude adoption without parental consent. On Norway, I expected to be asked about the situation and about the position of the European Union. I can only repeat that due to the fact that Norway is not a member state of the European Union, and moreover, as I said already before, the functioning of child welfare services is not governed by EU law but by national law, the Commission does not have any competence to intervene with the member states. Even it's more difficult case in Norway when it comes to the functioning of child protection and welfare services. This is the dry answer from the legal point of view. I can only reassure you that I try every time when I am in contact with Norwegian authorities to raise this problem informally. And the answer is always the same, that everything is happening according to the Norwegian legislation. In cases where the right to family life or the rights of the children involved are allegedly violated by the Norwegian child welfare services, it is for Norway, including its judicial authorities, to ensure that fundamental rights and especially rights of the child are effectively respected and protected in accordance with their national legislation. And the parents concerned can seek redress at the national level only through the competent national authorities, such as through an ombudsman or through the courts, and at the European Court of Human Rights once they have exhausted domestic remedies. Just short note on what Madam Ward said about the need to cooperate with the children's organizations. I can assure you that we are now in very intensive contact and cooperation with them when we try to ease the situation for the children in migration, where we, together with UNICEF and others, prepared a comprehensive material which addresses the problems for various angles. Ladies and gentlemen, thank you very much again for this debate. We all agree that the best interest of the child belongs to our highest priorities, and that the Brussels IIa regulation tries to tackle with the situation of cross-border disputes and cross-border scope and character of the problems, which fully authorizes the European Union the further action and well-targeted legislative solution, and other actions like improving the functioning of judiciary systems in the EU states, in EU member states, so that to increase also the trust between the member states to judiciary. And so I'm convinced that the proposal which we are preparing and which I will soon submit, the proposal of the amendment of the Brussels IIa, entails such a well-targeted solution which will improve the situation. Thank you very much.
Muchas gracias.
Thank you, Mrs. Jourova. And on behalf of the Council, Mrs. Henny-Pleasant has the floor.
Chair, let me underline once more tonight that it is important to stay true to our founding values. So it is our duty to protect those most vulnerable, including adoptive children. At the same time, and I repeat myself, but at the same time it is important to understand that the issue of the adoption of children is a matter which is not regulated at EU level, but by national laws and by some international conventions. As I said earlier, the Council awaits with great interest the Commission proposal amending the Brussels IIa regulation, and I am convinced that the amendment will further improve the function of this regulation, particularly with regard to the rules on parental responsibility. Clearly, Mr. Chair, we share the same goal, strengthening the rights of the child in the EU. This is an investment not only in their future, but also in the foundations of the Union. Now, one or a number of members referred to, in closing, Mr. Chair, but a reference was made to unaccompanied minors disappearing upon arrival in Europe. And I think it's important to address that as well. First of all, it is important that we get the facts and figures straight and that things are further investigated. But clearly, the thought alone sickens me already. Unaccompanied children are among those most vulnerable, and it is deeply troubling that professional gangs might exploit them. Now the question is, what is the EU doing? And I give you just a few examples. More than 200 million euros is being earmarked to target protection of children. Europol and Eurojust are active in helping to dismantle networks involved the smuggling of children. The European Asylum Support Office works on best practice guidance on assessment of best interests of the child. The EU helps member states to be better equipped to deal with specific needs of child victims of trafficking. And outside the EU, we earmarked 120 million euros for protection programs for vulnerable Syrian refugee children. Work with NGOs in, for example, Turkey, Lebanon, Jordan and Iraq. To conclude, Mr. Chair, it is important that EU member states work together to prevent children falling in the hands of criminals. Overall, there is, I believe, ample opportunity to improve the sharing of information between member states, and this is one of the focal points of the Netherlands presidency. Thank you very much.
Thank you. And with that, we close this debate. We'll move on to the next point on today's agenda. This is a brief presentation of various reports. First of all, Mrs. Kuneva on domestic workers and carers in the European Union. Mrs. Kuneva, you have the floor.
Thank you, Chair. Dear colleagues, we're talking about domestic workers and carers. We trust them with our houses, our children, our parents, and our sick. They allow us to have a career and to enjoy our social life, but they are invisible, they are undeclared, uninsured, and socially excluded. And they are mainly women. There are 2.5 million domestic workers in Europe, and 88% of them are women. They work long hours, with no days off, without medical cover, with no pension plans. They work in conditions that cannot be controlled because there's no way to inspect, there's no way to find them and protect them. Our aging population and the fact that women are entering the labor market means that we have greater needs for domestic workers and carers. The member states know this. However, they allow for these needs to be covered by the grey economy. They cut back on public spending and they take advantage of the waves of migrants as a new cheap source of labor. What we need to do is to document the situation in the member states at once. We need to have legislation that will cover decent working conditions for these people. We need to ratify and apply Convention number 189 of the ILO concerning domestic workers, which deals with their needs completely. We need to move forward with professionalization and certification, as well as adopt best practices such as the ones in France and Belgium. We need labor unions to come to them, because those workers do not know who they have to turn to. We also need to carry out inspections while respecting their privacy. And we need to inform workers for their rights and employers for their obligations. I would especially like to thank Ms. Tania Gonzalez for the cooperation we had. She drew up the opinion of the Employment Committee, as well as all of the other bodies that are working on the issue. We need their support, especially now, before the vote of this report tomorrow, because the Conservatives in this Parliament have asked for split votes